Thank you very much indeed, Mr. Speaker. I'm very pleased to have listened to this very, very interesting and useful debate. And I rise to speak to new clause 22 and new clause 17, which clarify the means by which a suspensive claim may be made to stop a removal from this country. And in this context, I want to briefly reply to my honourable friend, the member for Newbury, who's made a very good speech in the committee stage of this bill, opposing the amendment that I tabled at that stage, which sought to disapply the operation of the European Convention on Human Rights as a means to prevent removals. And her point then was that the English law already included protections which could be used in the same way as the ECHR. And of course, she's quite right. The jurisprudence of the UK does have a set of remedies against unfair treatment, and these still apply. And indeed, they are clarified in this bill. The contradiction to what the Honourable Lady Opposite was just saying, the remedies for a suspensive claim against a removal are clarified in this bill, and particularly the principle of non-refoulement, which is in our common law. Even without European rights law, we would have that. And so this policy does not contradict that principle. Indeed, it strengthens it with a clear protection for people who would suffer harm by being returned to their own country, or indeed any country. And now that that relief is in there and clarified, we need to block the spurious use of other domestic remedies which are no longer necessary. I want to thank the Minister and the team for their very constructive engagement. I'm very happy with where we've got to in this bill, and I want to quickly explore the issue at the heart of this debate, which is not really about migration, but about the sovereignty of Parliament to make the laws, including over this essential issue. And it's been established in recent times that, particularly in the judgment in Thoburn in 2002, that some laws in this country have more weight than others, and indeed are not subject to implied repeal. They essentially have the status of constitutional documents. And of course, the European Communities Act had that status until Brexit. And the other act which has this constitutional status is the Human Rights Act, which requires and enables British courts to apply the ECHR. Now that doesn't have a doctrine of implied repeal over it either. And of course, the Human Rights Act requires the courts to follow the judgments made in Strasbourg. Now, Mr. Deputy Speaker, I can live with anomalies. We don't want a hasty, destructive, ideological or populist rejection of the status quo of the legal arrangements of this country. That's not the British way. It's not the Conservative way. We can live with an eccentric inheritance from the post-war era. The problem is when it's not eccentric, but when it's deeply problematic, as it was in June last year, when the European Court put a stop on our removals policy, and that, in response to my honourable friend, is an occasion on which the European Court exercised an interference in our immigration policy. Now, I accept that that was just a rule of the Court, which in my view we could have ignored, but the government seemed to accept the legal advice that it was obliged to give immediate effect to that ruling. So I'm very pleased that we have new clause 26, which gives the Home Secretary the power to disregard Rule 39 interim orders from Strasbourg, but we still remain subject to Article 46 of the Convention, which obliges us to comply with final judgments. And for me, there are two profound problems with our membership of the ECHR. The first is that we have an inbuilt ratchet with Strasbourg rulings. Their treatment of the ECHR as a living instrument, to be interpreted in the light of whatever cultural ideas are prevalent or appealing to the judges. And thanks to the Human Rights Act, these rulings form part of English law. And at the same time, we have a willingness among lawyers here in the UK to employ the ECHR to frustrate the will of Parliament, to refer the laws that we make to some higher authority, to an abstract morality rooted not in custom or in the habitual allegiances that we have to each other as citizens of the same country, but rooted in their own liberal fantasies. Now, Mr. Speaker, I also believe in a higher authority, and one which respects the dignity and value of every human being. Let's call it the natural law. I believe that this higher authority is indeed the source of all our liberties and rights, and indeed of the ECHR, and of every other noble-sounding document in the West. It's the source of our morality, but the way this morality works out in practice is not through abstract theorising from on high. It works through the accumulation of case law and of the statutes passed in this place. Now, I'm not proposing that we come out of the ECHR now. I'm suggesting that if there is a further challenge to British sovereignty and the supremacy of Parliament, whether in Strasbourg or the British courts applying the Convention, then we have no superior obligation to remain in it. The superior obligation is to our own sovereignty and the supremacy of this place. This debate has exposed a difference between those of us who believe in nation-states and in the customary laws of nations versus those who believe in abstractions, to be interpreted by unaccountable judges, whether in their pyjamas or not. I'm very content with where we've got with this bill, and I support it unreservedly.
Minister to respond to the debate.